harmonization. It's a regulation that applies directly in the member states without any need for member states regulation, and that will cover all the European Union plus the EEA, European Economical Area. And maybe we can elaborate later on the other aspect of your questions.
Obrigado, Christophe.
Thank you, Christophe. Due to technical issues, I was not able to listen very clearly to the translation of what you said, but I was able to understand a little bit of what you said, some of the aspects about the implementation of the new rules of the DSA and DMA in Europe, and that they will also be applied most likely in 2024. So in Brazil, we try to understand how this topic has been discussed. That's why we have Dr. Juliana. And I would like to ask, following the same line of thought, how these regulatory rules can relate to DMA, and how can that reflect considering the Brazilian regulation and laws? Is there any concern when it comes to the market power of the big companies of technology in Brazil? Because the great concern is the big techs that are entering the market. So we have to think about protection of the market for Brazilian companies. How do you see that? Thank you so much for your question. First of all, I would like to thank the audience that is so highly qualified. I would like to say that it's a pleasure to be here with you in person in this big event of ABPI. I also would like to introduce myself. My name is Juliana. Differently from Paulo, I am tall. I'm 1.8 meters. I'm wearing a shirt that seems to be a dress, and I'm wearing funny shoes with like cat whiskers, and I'm sure that now you will all take a look at my shoes. I would like to say that it's a pleasure to discuss this theme, even though I am representing the Economic Defense Council. As Christophe made his disclaimer, I would like to say that everything that I say here are also my own private, personal positions, and they do not reflect necessarily all the positioning of the Council. But this is a theme, Paulo, that to us, it is a permanent topic of discussion. The greatest issue that we have now when it comes to competition, the greatest debate now is how we should, or if we should or not, regulate issues that are related to these environments that are new to us. So I think that Christophe touched upon some important topics, that we have new legal concepts. When we talk about digital ecosystems, try to understand what is the new aspect of this new situation due to these ecosystems, because we are talking about platforms, and many times we are talking about gatekeepers as well that are also different, have different designs. So we can't compare platforms within themselves as if they were all identical, because they are not all the same. So some of us use platforms. So we have the phenomenon of the social media that became social e-commerce. So you can use your social media to see something to buy or to sell. So you see the ads being tailored to your profile based on what you like and what you don't like, the pictures you post. So these are all interesting issues that involve a backdrop that I believe has been discussed within ABPI, which is the concentration of data and info in the digital environment. So the first thing that is important is in this movement is to follow, because we have to think about competition leagues as well. We have to compare that to the North American concept and to the European concept that have both evolved a lot in recent years, mainly the latest 2 decades, especially all of those that have been analyzed by the Council in Brazil, participating in the Organization for the Economic Development and other international forums. So the themes related to the economic power of these big techs is also something that interests CAD as well, CADE. And we are talking about a movement that we see in Brazil now, and I believe in many other places in the world too, which is the small tech companies sometimes getting ready to be sold. They don't want to compete with the big techs. So this movement, for example, of the killer acquisitions, which are the small startups, sometimes the maverick companies, which are those who start to have to compete with the big ones, and then they suffer a merge or a fusion of, they are bought out by other bigger companies because that is good for a business model of the big ones. And that sometimes doesn't go through the competition laws because our criteria are those of invoicing and we establish very clear objectives in thinking about the revenues of the company. And we have some cases like Facebook and WhatsApp that were not even notified in Brazil. And then what we could do, the analysis is not done, but it doesn't mean it couldn't be done now. So if we see some abuse of this dominant position in the market that a certain economic group has, can be, yes, indeed, analyzed by CAD. And we also have a proposal that we call exit, because we don't have, except for through advocacy movements that are not necessarily a law, but I believe that we all are very attentive of these discussions, because even though we don't have a direct consequence, we have indirect consequences. So we have to have our own legislation in Brazil. And one of these days I said that the million-dollar question is, and my daughter asked me, what is this 1,000 reais question? I said, no, it's $1 million. So the question is, should we have some sort of but should we be united? And I have participated in some legislative process, and sometimes you design a horse and you end up seeing the face of a dog. So that's what happens in Brazil. You have a certain goal at the beginning and you end up reaching something else because so many people work together trying to include something, add a suggestion, out of paragraph, and you end up having something that is not what is supposed to be the mechanism that is going to disincentivize this movement that we've been seeing in terms of technology and innovation, because nobody denies the positive aspects that we have throughout these years with all the digital services, even especially during the pandemic. So all of us that had some social distancing and were isolated saw a positive aspect of it. On the other hand, there's a lack of equilibrium between the companies because the big ones, they detain a lot of data from all of us. And at the same time, we have to think about how can we enter the market to be a rival to those, considering they create these ecosystems and this prison that they create. Because, for example, nowadays we can't remember anybody's birthday without social media. So WhatsApp for many people became a work tool. We saw some situations where WhatsApp was suspended for a while by the judiciary in Brazil and how much that impacted us. So this theme is very present in all discussions. We are following that. We have been producing materials about the theme. We've been debating that internally. But I think that this observation movement, observing what happens abroad and verifying where we can do a transplant, so to speak, based on our constitution, on our history, that is also a step that is yet to be made. So we are just observing right now, and I think that that helps us a lot. Yeah, talking about a moment to observe, Brazil is always observing large countries. And as you said, when you mentioned like a database, we have to create an intersection between competitive league and IP. And also, currently, we have a national authority when it comes to data protection. And I believe that you will have to have a conversation in that sense about many of the aspects. Why? Because this observation brought the GDPR, which is the General Data Protection, and Brazil ended up having also the LGPD, which is basically the same thing translated into Portuguese. So these are all ways of observing that Brazil has to take into consideration. And it's an interesting path to follow. And I'm going to pass the floor directly to Christophe with another question.
Protect the fundamental rights of users as well as promote innovation and competitiveness.
Well, thank you for the question again. I forgot to say that I have a blue a blue jacket and a blue pants, you told me that I had to present a little bit myself. So I'm Christophe, hello to everybody, and I have dark shoes, but very traditional shoes. Just to jump maybe on one or two words that you were just saying, Juliana. First one, you mentioned the word data. I think it's a key word in the topic of our discussion, because I think we're talking about competition law, etc. We should talk about convergence, because now we are at a moment where we clearly see a regulation that goes towards convergence between transparency, privacy, which could seem a little bit contradictory, but it's not. Data protection, consent, fairness on the market, fairness regarding the advertisers, but fairness also vis-à-vis the destiny of the advertisement. So it's really the key point, I think, of this regulation. Now, to address partially your question, because it's, again, a broad question, I will concentrate at this stage on the Digital Service Act, and maybe later we can come back on the Digital Market Act. I think I have some criticism against this regulation, but on this aspect, I'm told to do something. You want me to take it off? To put it here? It will be better? Okay. If it's like this, it's like this. It's technology. So, I think regarding the balance between promoting innovation and trying to regulate to a certain extent the behaviors on the market, the proposed or the act, the DSA, is pretty well constructed, because you have several levels of implication regarding the regulation. The first thing that is important to know under the DSA is that there are de minimis. For small businesses, a lot of obligations simply do not apply. So basically it creates a sandbox for innovation. You can start, you can propose on the market, and if you are successful, means that you earn money, then you go to the upper level, but you have the money to face the new costs of the regulation. And if it's really a fantastic success, then you will go upper to the very large online platforms or very large search engines, and you have even more money. And if you became a gatekeeper, I think money is not even a problem to go through the regulation. So now, how is it implemented? First thing, it works on the liability, the accountability of the online intermediaries. Basically, there are some exemption of liabilities unless they are aware of illegal content, illegal behavior on their digital service. And this is the key point, and where the Digital Service Act is interesting is that is proposing a certain number of channels for the authorities, but also the individual, the businesses, to complain to the service provider about content. And the service provider has to make a decision. So we can say it is good that it's the service provider itself that makes the decision. There are some possibilities to control this from the authorities' perspective. There are also a concept of trusted flaggers that are private entities, but that are recognized as trusted to complain to an online intermediary, and it will have to address in priority the complaint of those trusted advisors and to clean the content if it needs to be cleaned. And it's only if they do not do this process that they can be held accountable for that and be responsible for that. It's very interesting for IP lawyers, because it's very clearly a way to enforce IP laws without having to go necessarily to court. It's also very interesting to try to identify some nasty traders on the digital market that specialized in counterfacting business or other infringement of IP laws. So basically that's the main tools I would like to mention. Just one more that is for the very large platform and very large search engines, which is the risk assessment. The Commission and the DSA impose to those operators a risk assessment procedure where they have to anticipate the risk of attempt to fundamental rights, of violation of law, and to propose measures, and this under the supervision of the member states' authorities. And that's where I see a form of balance between controlling, supervising, monitoring, but leaving some room for improvement because, as I mentioned earlier, you have those scales in the application of the regulation that allow small players to start and to try and to see if it works.
Obrigado, Chris.
Well, thank you, Christophe, for your explanations in that sense. But now I will ask you both another question on that same line, but trying to understand a little better the antitrust authorities.
Streamline antitrust authorities, efforts within European Union member states, and how might this influence other jurisdictions? Acho que isso daí vai pouco mais também na linha dessa influência.
This is more in that sense of the influence of the European authorities and also in Brazil. Well, I think that is an important point. When we talk about a phenomenon that reaches all, we see this happen. We don't see this happen only in Europe, only in the United States, and perhaps there's a point that might be for reflection in the sense that there are geopolitical discussions on that. Where are those big companies? And a fair amount of them are in the United States, where we started to see recently with this change in the Federal Trade Commission leadership change, some more concern about this economic power. The dominant position of those tech companies focusing more on all the effects we have, the potential effects to competition, because the North American trend up to that moment was to not interfere in any way in those markets, not even having some kind of responsive regulation. In Brazil, we have that kind of model, and we had something like that during the pandemic because of the massification of the use of the internet for services, and even the platforms had to join the government platform at the time for dispute resolution, given their big utilization. And it was a way to monitor those activities and to identify where there could be some kind of flaws or some kind of abusive practice that required note. And that was a work then strengthened by the technical agreement that was signed, thinking about the undue sharing of consumer data. But when we look abroad, it is interesting because I see that we sometimes feel have this inferiority complex because we have good experiences here which we do not share, when we have a tendency to think that whatever comes from abroad is better, that like our neighbor's lawn is greener. And when we think about transplanting models at work, I think we should take care in the sense of trying to identify how much our efforts should be made at that moment, given uncertainties, because we're talking about markets which are not very much known, at least in Brazil. Much of what we evaluate are situations of big companies which are not here, but which we consume here. So it is natural for us to follow this up and to have this concern, both in terms of identifying any practices which might be against the economic order resulting from abusive behavior. Those are companies with economic power. Those are the companies with highest market value. but the themes that serve as a reference for activities are cases that you'll find abroad. Then there is a difference, at least in the past 5 or 10 years, in the way Europe addressed these themes compared to the way the United States addressed them. And now we see more of a concern with an ex-ante analysis. Now there's some kind of an ex-ante analysis rather than ex-post, because then people say that are becoming too big to regulate, so we should see this before. But anyway, we should think about a more transdisciplinary way to do this, and with answers being brought not only by law, but we'll need to deal with people who deal with computing and things which are not necessarily legal, because we cannot feel tempted to create a rule thinking about the negative effects of a regulation that not much discussed, in order to not create an environment that might discourage innovation. So to evaluate what is done abroad, and we should see if there is an impact. Yes, we're discussing this in Brazil, and then we started to discuss when the first case was open abroad. We have several cases that were analyzed by CADE. There is a book by Victor Fernandes related to competition law platforms. But as I say, if you want to choose a difficult theme, it will be this one, because everyone's talking about it. To follow up everything that is being discussed and produced is a challenge. In our case, we're not so much worried about the geopolitical aspects. We want to make companies remain here, but the fact is that considering what we have today, and regarding the antitrust law, Brazil was very much based on good international experience. If the results we're obtaining has been favorable, especially, and this will be an incentive for us to think about something here. And we will have a discussion on who will do this, what will be the authority to handle this theme, and obviously there are several arguments in terms of making use of regulatory agency structure. But I think the community as a whole, and those of you who are here, who are lawyers and researchers, you need to take part in this discussion, because we still have do not have a certainty regarding the path to take in Brazil, and the importance of this theme is even a challenge for us in this Intellectual Property Congress, because most of the lawyers, and especially those which are company lawyers, are much more related to intellectual property law than to competition law. So we discuss matters related to this intersection between antitrust, competition law, and intellectual property law. But regarding what you said, saying that companies become so big, then you can't regulate them anymore. So there's ex-ante discussion and about the Digital Market Act. Now I'll ask a stronger question to Christophe in the sense
issues of large digital companies acquiring smaller firms and consolidating the market without allowing the trial of the new partner players. How does the creation of DMA enable competition thrive? Furthermore, consider that even though the obligations are proportional to the size of the companies, every time you impose an obligation, you create an entry barrier. How can this regulation reduce the entry barrier and foster new players in the market? O que é claro é exatamente.
What is clear precisely how to address these big companies who merge with smaller companies, and we're talking about innovation and also about competition. How can this be regulated? How will you deal with this? Brazil as well.
I always say thank you for the question, but in fact, I don't think at all thank you, because those questions are terrible. So, but I will try to say something about that. First of all, technically speaking, in the DMA, Digital Market Act, there is a very interesting provision that says that the gatekeepers who intend to merge with smaller company have to notify the European Commission even if the thresholds for merger control are not reached. So basically, it is obvious that apart from the creation or the strengthening of a dominant position, the European Commission wants to have an eye on their power. And here I would like to make some comments regarding what Juliana said on the geopolitical aspect. And here again, I insist on the fact that it's my personal views, nothing to do with the LIDC, because it will be a little bit sensitive. But I mean, every time the European Union do some horizontal harmonization, it always has to do, to a certain extent, to protectionism. It has to be said, and you have to be cautious of that. And in our case, Juliana said it very well, all the targeted entities are US-based entities. They are not European. And everyone knows that in the EU, the digital economy is probably, at least its growth, is probably a little bit late compared to what is going on in the US. So yes, you have the fundamental rights, fair market, fair practices, etc. That's the nice color of the coin. But you also have some other objective, that is to protect the European market or give the European market an opportunity to develop in order to fill a little bit the gap. And yesterday we were asked by Mrs. Washington to look at the future. I would like to ask you a few minutes to look at the past. In 1890, in the US, the Congress passed the Sherman Act. The Sherman Act was passed in order to give the opportunity to the court to dismantle Standard Oil of New Jersey, the company of Mr. Rockefeller. And Senator Sherman said, if we cannot accept to have a king that govern our nation, how can we accept to have a king that govern our production, our market, our products, our transport? And in 1911, the Supreme Court validated a decision of a court in the US to dismantle Standard Oil, the big conglomerate of Mr. Rockefeller, in 43 different companies. And what I'm looking today to what is happening, and I have no opinion whether it's good or not, but I think we are following a little bit the same trend. We realize that private economy, through the size, through the impact in the society, through the huge amount of data, and data is money, it's much more money than data. They probably have more powers than certain states. And at a certain point, there is a need to say, we suspend a little bit the game, and we will see how it works. And I think that some of those interests are also, I'm not pretending that the European Union intends to dismantle the GAFAs, certainly not. But it's clearly a tool to allow, and if you go a little bit in the detail of the DMA, they have to share their data under certain conditions. They have to give information on how the algorithm are using the data to advertise to the end consumer in a targeted way. They have to be, or they are accountable towards the advertisers on how do they practically really do the service they sell to the advertiser to make sure. And there was an interim measures in France on July 13, so very recently, against Meta, because Meta was putting some barrier to independent company to verify how the ad that were paid but advertisers were in fact promoted by Meta. They are not allowed anymore to promote their own services in a better way than they do for third-party services. So I think all of this has to do with protectionism. And as far as inspiration is concerned, I think some of those rights, in particular the right for an advertisers to request the platform to justify the way the algorithm is functioning, to promote the advertisements, will probably inspire the business all around the world. I don't think, like the GDPR, does not really inspire the lawmakers, but certainly more the businesses.
Obrigado, Christopher.
So thank you, Christopher, about, in a clear way, from our point of view, understood perfectly when you talk about the European Union, when you talk about protectionism and everything else, but in a one way or another, not only for business, but also the GDPR, as far as I understand at least, was clearly an inspiration for LGBT in Brazil when we talk about data protection. And now these regulatory acts, both LIDC as DMA, are regulations that will have an implication on protection not only of companies that are part of the European Union, but also out of the European Union, be it in Brazil or the United States, wherever it may be. So within that prospect, that perspective of international trade, will address Christophe once again, asking precisely something like that.
UA clearly aims to establish global standards, as we talked. How will the DMA be applied to international companies operating in Europe? In what aspect might they be unintentionally creating some form of international entry barrier, especially concerning countries that are not part of the developed list? Prevent a player, even a Brazilian one, for instance, from offering its services without adhering to these regulations?
He cannot, sorry.
Huh?
Not possible. Not possible, sorry, because the DMA, again, just to repeat, both are regulations, so immediately applicable within the whole European Union. No need for national regulation. The DMA applies to all gatekeepers that offer services to persons, legal or individual, located in the EU, like the GDPR. So, no question, if you are Brazilian, you offer services there, it applies to you. The DSA is a little bit different because it's not based on competition law, so the effect theory does not apply. So if you want to offer digital services within the EU or the EEA, always understand the EEA, then you need to designate a representative in the EU that will be responsible for the violation that you will commit to this Digital Service Act. So no way.
Okay.
No way. And it's a form of...
Okay, but considering that each member country of the European Union will create its own legislation, what will be the entity responsible for enforcing the DMA, for example? And Juliana, in Brazil, the perspective... não, vou falar... A perspectiva é que seja...
So the perspective in Brazil is that this regulatory agency might be Anatel, with a legislative proposal in that sense. What are your views on that? And what is the possibility? I think you mentioned this before, CADE, about CADE having this influence, this ex-ante examination. What can you tell us about it? Well, any concentration act, and when we talk about concentration act, we need to understand that a JV, a joint venture, not necessarily is a purchase or participation. Any partnership design that may involve two economic groups that reach 750 million in the year before. And on the other side, 75 million from the economic group must notify CADE. So we have quite an atypical situation, as in the case of a big case like that of WhatsApp. They didn't have this income at the time, in spite of the value of the operation exceed billions of dollars. So one of the criteria established was really the amount of the operation that goes beyond the amount of
No Brasil, se precisamos, se não precisamos, eventualmente repensar.
of invoicing. So really, in fact, there is already necessarily companies need to look at CADE anytime the antitrust authority, in case you already have this level of invoicing established by our revenue, what the problem is that we do not have this revenue this side. Well, but the institute would look at analyze the conduct. So we have a dominant position of the market. It can be a unilateral behavior or unilateral conduct. It doesn't have to be an agreement between competitors. Evermore, CADE has taken seen address unilateral conducts, which many times people remember consumer law but do not remember competition law when it is. I'm certain that our legal community thinks about the consumer code, but when you have abuse of dominant position, that it is also illegal. In those cases which involve technology law, if we're talking about a technology company where you have that tells you that you need to buy a package of services in order to keep on using the services, and there are several examples, this is a theme for antitrust agencies. So those are important matters to remember, at least licensing matters that relate to intellectual property. So when we talk about transplant, you see that one of the themes not long ago when we had in Brazil, they had investigation related to litigation which to extend your law of intellectual property in a way that the antitrust authority considers non-competitive.
So there's no abuse in this case, but we call it a mitigation behavior, which is a transplant we made here. But these are good examples. So how the authority should be, which body should represent it. So I like this kind of debate, but it brings an idea of liability, which Anatel has been thinking about already, because we think that we have a space for that. And obviously, if we decide to deal with it in a certain way, we are going to need more structure, because we're talking about a thing that will require a different approach from the agency, thinking about budget, among other things, because we have to create one more competency. And also, before NPD being created, we discussed the possibility of absorbing this competency. So these are valid discussions, and I believe that the fact that we already have some structure is positive to a certain extent, and maybe Javi will be able to talk to us a little bit more about the history of the institution. But I saw it from outside, and I knew how difficult it is to begin a new authority with the demands already existing. So that's a challenge. But I do believe this is a discussion that will show that the decision will have to be taken by more than just one ministry, involving other authorities that are interested in the theme. But we have this movement taking place already, and we see that there is an open mind about this possibility when it comes to the experience that we see in Europe, for example. And I think this is going to be a great debate for the coming months, and I believe that we will not be isolated thinking about it. We're going to be following what's going on internationally. And I think that from the point of view of CAD, my institution, something that has to be clear is that regardless of the creation of a new institution, a regulatory body or not, or having a new legislation or not, CAD is still involved every time there is a possibility of abuse on the market. We are always monitoring mergers and fusions, and we have to think about that because this is our job. That's our responsibility. So we are here for all the regulated bodies, all the regulated institutions. So even if it's telecommunications or whether it's IT or whatever, we have to be notified. But we saw this happen previously, for example, with the sector of electricity. So we are now talking about transversality that is interesting in our country because sometimes you have three different bodies analyzing, assessing the situation, and that creates a barrier, so to speak, because we have to follow everybody's strategy as well as we have to do our own. So we have to think about more than one institution, which is difficult due to the fact that this is a theme or a situation that underlines more than one institution, just like we dealt with WhatsApp before, where we had basically 4 or 5 institutions dealing with it. Excellent. This opens even more the path. It paves the way for a competitive market as well as IP. It paves even more way for the professionals to act in this area of the antitrust laws and whatever is related to CAD, your institution. So that's why I believe that everybody is really interested in the theme and paying attention to what we are saying, regardless of the technical problems that I had here with the translation because there was some noise in my headphone. And now going back to you.
Enforcing DMA and DSA in Europe.
Yes. Well, again, just before addressing your point, I wanted again to support what you said, Juliana, or be inspired by what you said. Again, this convergence creates some difficulties to understand who is doing what. And for instance, I just mentioned a few minutes ago these interim measures from the French authority against Meta regarding fair access to data for third parties that are verifying the way Meta is in fact proposing advertisement on behalf of its clients' advertisers. This decision, that is a decision from a French authority on interim measures, mentioned 20 times DMA. The problem is that DMA is not in force at the time of the decision. And the second point is that the French authority is not supposed to enforce DMA because it's the exclusive competence of the European Commission. And I will revert to this in a few seconds. So it's interesting to see that it has an influence because the French authority, based on interim measures, based on Article 102 of the treaty, abuse of dominant position plus national regulation, say, look at the DMA and say, oh, it goes in the right direction, so I go in this direction. Another decision of July 4th from the European Court of Justice on a question raised by the Federal Cartel Act in Germany. The question was, is it possible for a competition law authority to rule under competition law, a violation of competition law, because of the non-respect of GDPR? And the response of the court was very clear. There is nothing in GDPR that prevents another authority to apply or to consider GDPR's violation in order to assess a situation under competition law. So clearly we have a convergence. Now, to go back to your question, basically the Digital Service Act will be enforced by the national authorities, but no need for national implementing legislation, not at all. So it's directly applicable. Regarding the DMA, similar situation, no need for national law implementation regulation. There will be a problem in Germany, because in Germany they have national legislation on online platforms. So in principle, they cannot maintain this regulation. And in the DMA, Chapter 3, Section 5, shall be enforced exclusively by the European Commission. But for the rest, it's a combination between member states and the European Commission. So it won't be very easy to understand who will do what. And as I said, even before it is formally enforced, the national authorities already start to use it. So it will be probably, there will be probably too many people who want to enforce it than not enough.
Obrigado, Christophe. Eu estou vendo aqui que
Thank you so much, Christophe. I see that we are running out of time, so we don't have a lot of time to finish the panel. And I would like also to address a last question to you guys, but also keeping in mind that I would like to offer the audience a question that is, we ask, please, to be objective and brief, and also people who are watching us online. So I'm going to open the floor. I'm going to open the iPad of the event, and I will see if there's some question. And if that's the case, I'm going to give them the chance of asking the question. But just to finalize, I would like to ask Juliana and Christophe. I'm going to ask the question in Portuguese because the translators can translate it. Has there been any difference in the treatment of the digital market regulations that is more mature in the emerging markets? Do you see a difference between emerging markets and mature markets? Well, our constitution does that already when it comes to the small companies. So from the point of view of the constitution in Brazil, I believe that we always have this trend of providing a differentiated treatment to the smaller guys, which doesn't mean that the future regulation, if there is one, will not touch upon that. I do believe that there are some differences that cannot be somehow disconsidered. They have to be considered. So we are talking about some big tech companies that in fact have an amount of data already and information that are not to be not considered. And this is a factor when you're talking about competition. So this is a great topic that we have to address internationally, actually. So we currently have within the platforms a problem that is focused in Europe when it comes to self-preferencing. And so you should have on the platform the production of products, and they have information of the market on both sides. So of course that is a competitive advantage. So these are some topics that will somehow be touched upon here, but from the constitutional point of view, I believe that we already have the support to the smaller companies, but they will have a great challenge in competing with those who already have a great number of data that is so big that it's difficult to even identify them as competitors.
Sorry, I had huge noise in my headphone. So just in few words, I think, yeah, for sure there should be a differentiation of the regulation depending on the maturity of the market. I think, as I explained, that it is the intention of the European Union to have these different thresholds from very small undertakings to big undertakings. I don't know if it will work or not. The only thing that is clear is that they made sure with the definition they used that nobody on the digital market will escape the regulation. So maybe it will be exempted, but it will not escape the regulation.
Olha, obrigado, Christophe. Obrigado, Juliana.
Thank you, Christophe. Thank you, Juliana. Unfortunately, we don't have time for any more questions from the audience, but you all have ABPI's email, and this email you can use to send the questions. And I would like to apologize to those who were watching us online, because on the chat, based on what I could observe, we don't have any questions, but we have some complaints when it comes to the noise. They could hear me well, but apparently the audio from Dr. Juliana and Christophe was not so good. But what we wanted to do was to have an interview style, like a by the fire kind of conversation and a fireplace conversation. So I hope that you've had some new ideas and insights about the market, which is interesting to all of us. Thank you so much.
Very much. Thank you, Christophe. It was quite complicated to